Hello, and today we would like to welcome Craig Cutler. He's a member of the Cape Bar. He's what's known as a senior junior advocate. He's been a member of the Cape Bar for some 17 years. And Craig, a very warm welcome to this interview. I'm really looking forward to this and your particular angle on things.
Thanks, Ian. Thanks for having me on your program.
Thank you very much, Craig. All right, well, let's just get straight into the content. And Craig, what I'd like you to talk about, and for those that might be encountering this series of interviews for the first time, these interviews are founded on the Expert Witness Guide, which is produced by the South African Medico-Legal Reports. And there are a number of chapters dealing with different aspects of expert witness evidence. But the idea with these interviews is to take practitioners who actually work with this area in the field on a daily basis and to put some real sort of meat on the bones and bring these principles to life. And I'm very, very pleased to say that you've agreed to talk about the trial preparation stage today, and we've got some interesting content, I'm sure, coming up, and to see from a practitioner's perspective who deals with this on a daily basis how this plays out in practice.
Yes, excellent. Thanks, Ian.
All right.
Yeah. Ready to go if you are.
All right. Okay. Let's then start off the first section that I'll refer you to, and just for those watching, I'll refer Craig to particular sections of the book, and then I'll allow him to talk really fairly freely and to elaborate on that section with particular reference to the type of work that he does on a daily basis. And the first section we're going to look at is paragraph 4.1.2, the trial preparation stage. And I'll just make quick mention that this stage begins once it is apparent that the matter will be defended. So once summons has gone out and there's now some appearance to defend or some formal indication from the defendant or defendants or respondents from the other side that the matter is now going to be defended. This period is characterized by the parties defining the issues which are really in contention and refining their respective cases accordingly. Key processes of this stage include the Rule 37 and Rule 37 capital A procedures, in terms of which the legal representatives and expert witnesses conduct various pre-trial meetings and conferences, the discovery of documents, in terms of which relevant documents are exchanged, the inspection of documents or objects, and the examination of parties. And then I should just say that in particular, obviously in this book, we are particularly interested in the expert witness's role in all of those pre-trial processes. All right, Craig, well, that's the introduction. The floor is yours. Take us through your thoughts on that.
Thanks, Ian. Look, just to preface the fact that, at the bar, I do a mixed medley of work, which involves work on motion and work on in action proceedings. And of course, we're talking here generally about action proceedings. Those are matters that will go to trial or to arbitration, for that matter. And just to say that, I'll just preface my commentary really on the fact that I find myself using expert witnesses mostly in the areas of commercial disputes where accounting evidence is necessary. That can often be in the case of an ordinary commercial dispute, but also in the insolvency space, of which I do quite a lot of work. And often the expert evidence of an accountant is useful to assist us to explain to the court what the financial position is of the company. And then in the other space where I use expert witnesses on a frequent basis is in the construction space as well. As you can imagine, the construction being as technical as it is, it's often useful to have an expert there. So that's the background. So in other words, I suppose my take may be slightly different to. I know that you come from a more medico-legal background, and I understand that's the direction that your course is aimed at. But I think certainly my observations, I think, are of universal application when it comes to a trial lawyer preparing for trial and how and when to use an expert. So to that end, if I may say, I think your handbook, your manual, is very usefully divided up the trial processes into the various stages, and that is exactly how we as trial lawyers prepare for a trial, or as I referred to it earlier, as an action proceeding. And your paragraph 4.1.2 and also 4.2.1 of your manual, you deal with the key processes in the trial preparation stage. Now, you already gave the listeners a rundown of what's involved in that stage. And your first observation there really was understanding the issues in dispute at the trial preparation stage. Now that obviously involves getting a handle on the pleadings, because your listeners may or may not appreciate that in these types of trials, the issues are defined really by the pleadings. So that's taking what the plaintiff says and then looking in the statement of claim or the particulars of claim and what the defendant says in the plea, and trying to establish from that perspective, on that basis, what the issues are in dispute.
Yeah, Craig, if I can just pause you there, just for expert witnesses who may not be familiar with those those terms, there are just one or two that I just want to break down for people who may not understand them off the cuff. So firstly, you talked about motion and action proceedings. So motion proceedings, really, there's this special court which deals with matters where it's not necessary to call oral evidence or to lead witnesses in person. And those sorts of disputes are dealt with on the papers. So, and typically there's no real dispute of fact. The term that we use, real dispute of fact, in those proceedings, and the judge can just decide the matter on the papers. We do find occasionally you'll have an expert report, but generally experts aren't typically involved in that type of proceeding. Much more the other type of proceeding which you referred to, which is correctly called action proceedings. But if the viewers just think of that as that's the sort of case that goes to trial where witnesses are actually called in person, and then when you talked about the pleadings that started by a summons, and people will be familiar with summons, it's in sort of everyday parlance, but then there are various formal responses. Most importantly, you mentioned already, which is the plea. And when you read the summons and the plea together, the summons sets out the plaintiff's case, and then the plea will go paragraph by paragraph through the plaintiff's case and deal with what is admitted and therefore common cause, what is in dispute, and then there's another category where it's neither admitted nor denied, and then that's the type of category where it may be in dispute. But certainly the issues will emerge from the pleadings, and that really, especially from the advocate's point of view and the attorney's point of view, that's the starting point as to what's in dispute. We will look at this, I'm sure, later, but it's a very important point you're making, Craig, because that's the genesis of what's in issue between the parties. It's a formalized crystallization of the state of play that the experts should actually be aware of, particularly when they start engaging in meetings with other experts and preparing joint minutes. So thank you for that. And I just wanted to just give a quick definition of those different terms. But please continue, Craig.
Thanks, Ian. Yes, that's helpful. So the crisp point really is that the issues in dispute are determined by an analysis of the pleadings. And I was going to suggest to listeners that from a practical perspective, it's really the job of the trial lawyers to analyze the pleadings. Obviously, a copy of the pleadings is routinely provided to the expert for the purpose of briefing and preparing the expert. But the takeaway point, I think, is that from an expert's perspective, an expert is not expected to be a lawyer. And I think it's fair for an expert to ask for clarification from the briefing legal team as to what the issues are that are in dispute.
Yeah, very much so. Very important point that, Craig, is that the expert work with the legal team to understand what the issues in dispute were with the pleadings, and also they often come in later in the process. So that back and forth between experts and lawyers, and I can't emphasize that enough. It's a very important point you made there, Craig.
Yeah, thanks, Ian. And that brings me to the next point is the problem we have now, and you've made this point in your I think it's actually a paragraph 3.1 of the handbook. We don't need to go there, but you pointed out that the rule is now changed. Rule 36 sub 9 has now changed, so that it's now a requirement to produce the expert notice and the expert report at 30 and 90 days respectively after the close of pleadings where you are the plaintiff. So it used to be in the old days, we used to have the pleadings would close. In other words, the parties will have filed the whatever further pleadings they would have wanted to, and then after a 10-day period, the pleadings are deemed to be closed. And then one had all the time in the world to work out what the issues were in dispute, what issues required expert evidence. The problem now is, since the rule has changed, is that almost the very next step in the pre-trial preparation stage is you've got to decide quickly, do you need experts? And then you've got to brief the experts properly.
No, very much so, and that's a very important practical change, as you say, Craig. So the briefing of the experts is very closely linked to the close of pleadings.
And you've mentioned in paragraph 4.1.2 the various steps in the trial preparation stage, including Rule 37 and 37A, capital A conferences. Just for the benefit of the listeners, those are rules that provide for, Rule 37 provides for pre-trial conferences to be held between the parties, and Rule 37, capital A, provides for judicial management of pre-trial processes in order to try and ensure an orderly trial. Now, again, what would happen is, in the old days, one would go through all of those processes. To some extent, the issues can sometimes be narrowed by those processes, depending on what admissions and one manages to secure in the course of that process. But now, unfortunately, it's as we mentioned, it's the other way around. The expert reports must be produced. The notice and report must be produced first, and then, rather strangely, those pre-trial conference procedures are only then engaged afterwards.
Yeah. No, that's correct.
So, and then just on just a further point, you've mentioned at paragraph 4.1.2 the pre-trial processes, including further and better discovery, requests for trial particulars, requests for admissions, etc. Now, again, just to explain to listeners that those are really processes that we use as trial lawyers to try and secure more documents usually from the other side, but also from third parties by way of subpoenas and that, in an effort to make sure that we are we're approaching the matter on the totality of all the documentary evidence that may be available to the parties.
Yeah, that's right.
And just to,
sorry, Craig, just to tie that in. So I think that, again, it's the technicalities of how discovery is made and the exchange and inspection of documents and objects, etc., really is in the province of, as you made the point earlier, that's in the province of the legal team. But I think that
yes.
for the experts that will be watching this, what is important to know is that these processes exist. In other words, if they are preparing a report and they believe that there's a document out there that would be relevant to their opinion, they can alert the legal team to that, and then the legal team can utilize these mechanisms to secure that document. Similarly, with an object, if there's some object that needs to be inspected, there are formal court processes which allow the legal team then to have that object made available for inspection. So I think that's really the takeaway for the experts.
Yes, that's a good point. And I suppose just following on from that, there would be nothing, if that transpired, there would be nothing to prevent that expert from putting in a supplementary or follow-on expert report
Indeed.
after having inspected the item or secured further documentation.
Absolutely.
And that's really what I wanted to say about the pre-trial preparation stage.
All right. Now, Craig, I know you want to talk about paragraph 4.2.3. If that's the next paragraph on your list.
Yes, I think it's 4.3.2.
Oh, right. Okay.
And that is evidence in chief.
All right. Just bear with me while I catch up. You can do a bit of editing here, Craig.
Page 152. Sorry, 151.
There we go. Four 4.3.2. Yeah, okay. All right. So, yeah, okay. Evidence in chief. Yes, this is a very interesting topic, Craig. And I know you're going to take us through the pre-trial consultation with the legal team, and this is where the rubber really does start hitting the road. But yes, please go ahead.
Thanks, Ian. Yes. So the point that you make in under paragraph 4.3.2 really pertains to preparation for evidence in chief. I mean, here we're talking about preparing our expert witness, and you've made the point that the witness should have had the opportunity to prepare with counsel before the witness enters the witness box.
Yes.
Now maybe we can, and I think it sounds like a rather obvious statement, but it's not always applied.
Yeah.
And I think we just break that down a little bit, because to explain that if I was acting for the plaintiff and I'm going to use the expert witness, and I have the onus and the duty to begin on certain issues that are in dispute, then I'm going to take the expert. I'm going to consult with the expert, make sure that the expert and I understand each other, and then use the expert and lead that expert in so-called evidence in chief. And that is to say that I'm then going to lead the expert usually through the expert's report, and I'm going to utilize the evidence and the opinion of the expert then to bolster my case. Now, one would think that that's an easy process, but it's not. And a lot of lawyers, as you'll know, Ian, say that it's leading your witness in evidence in chief is to some extent more difficult than cross-examination. Now, just to explain for the listeners, that I would lead the expert in evidence in chief, and then when I'm finished, the expert will be cross-examined by counsel for the other parties in the case. Now, the difference between the two processes is that because we can't ask for the plaintiff when you're leading evidence in chief, you can't ask leading questions. You have to ask open-ended questions. And so therefore, it is absolutely critical that counsel prepares with the expert witness properly. Because if the expert witness gives the wrong answer or misunderstands the question, it's then extremely obvious to the judge or the finder of fact that the two of you, your Strictly Come Dancing routine has gone off the rails completely. And because you can't cross-examine your own witness. So if I don't elicit the right response from my witness, from the expert witness, I can't go then back to the witness in evidence in chief and say, no, but hang on a minute, don't you mean this or that? And so that is why the preparation stage for evidence in chief in respect of your expert is absolutely critical. So we often say a rule of thumb as counsel is that you're never going to ask a question of your witness to which you don't know the answer. And that's why of all the stages, this is probably one of the most important to my mind as counsel, is to make sure that you spend lots of time with the witness. You get to understand the perspective the witness is coming from, and then you go carefully through each aspect of the witness, of the notice and whatever expert report the witness has produced, and that as counsel you carefully understand what the facts are upon which the opinion is premised, and that you understand the reasoning employed by the expert. And quite often that's the expert edifying the counsel, because of course we often don't understand the technical nature of some of the questions. And one of the strengths I've found, one of the advantages of a good expert is that they can dumb things down.
Yeah.
I know it's a terrible phrase, but they can explain they can explain concepts, detailed concepts to counsel, so the counsel can then in turn explain it to the court. Exactly. And that's a hallmark of a good expert. So the idea then is to cover all the points raised in the 36(9) notices. That's one of the points you make in your handbook. And then you've got the section that I just wanted to touch on, tips for experts. It's at page 152 of the handbook, and it's tips for experts evidence in chief. And that's just a list of a sort of process list. Again, I like the way that you've broken everything down and you've got these very useful lists. That's exactly the one I'm looking at. And then there you've broken it down into the various stages as to how to really go about getting the witness's evidence into the record. So one is introduction of the witness. 2, establish academic and other qualifications. 3 is establish the reputation of the witness. 4, allowing the witness to state all relevant facts on which the expert's opinion is based. 5, ask for the witness for opinions and ensure that the reasons for each opinion are fully given. And then also 6, ask hypotheticals of the witness if it's appropriate in the circumstances. Yeah. And the reason for that is one is not always sure what facts are going to be found to have been established and what facts may not be established. But the aspect of the expert and witness and facts is something that I want to come back to. Yeah. But just for the purposes of this segment, I think this tips for experts is well set out and is usually followed.
Yeah, that point on facts. Now, just before we move to that, just one thing I'd like to add there, Craig, is that if we look at point number 5, so that's where you ask the expert for what I always say is the bottom line, which is what's their opinion or their conclusion, and I really do reinforce with both lawyers and experts that what the expert is doing is making an argument. And so there's a set of premises and a process of logical reasoning, and we've looked in other videos at the importance of that process of logical reasoning and how the courts approach that. But ultimately, they've got to give an opinion, and they must be prepared to give an opinion. They must give an opinion on the issues that are actually in dispute. So, for instance, if they're asked about whether a medical practitioner, whether the conduct complies with the standard of the reasonable medical practitioner, they must sort of what's the expression, grasp the nettle, and they must give an opinion on that particular point because it's an issue in the trial. But obviously, it's not just the opinion; it's also that the facts and the reasoning process are important to persuade the court that the judge should accept that expert's evidence. And so, I'm interested to hear that you're going to look particularly at the facts, because that in practice is very often, where the real sort of contest between experts happens. It's a common feature
Absolutely.
for cross-examination. Yeah. All right. Sorry,
Absolutely.
Craig. So please
Well,
continue.
yes, no, thanks, Ian. I mean, that brings me precisely to that point,
Yeah.
which is, certainly in just to posit it as a sort of real world scenario is, I often act in matters where we act on behalf of a liquidator who comes to the affairs of a company in liquidation as a total stranger. And the liquidator's given a half a room full of boxes of files and documents, and they've now got to make sense of the financial affairs of a company. And think of the scenario where often a liquidator will pursue claims for malfeasance against the erstwhile directors of the company. It's a well-known action in terms of Section 424 of the Companies Act. And in terms of those proceedings, an erstwhile director or corporate controller can it be held to be personally liable for the costs of the company or for the debts of the company if that person was party to the carrying on of the business in a manner that was reckless or fraudulent. So now you've got this. The problem is you've got a liquidator who comes to this massive wealth of information as a stranger. So normally what the liquidator will do is get one or several accountants, expert accountants. Quite often they'll be forensic type accountants, and half of the difficulty in a case like that, and this is where we use experts assiduously, is to try and establish the narrative of how historically the company was run. Now the problem is we're all new to this thing. We've got no idea whatsoever, and that's where and there's good authority for it. I won't bore you with them now, but I mean there's a couple of authorities we often rely on in explaining to the court that the expert is not just there to assist the court with providing an opinion, but also to assist the court with identifying the pertinent facts. And that's where I wanted to say, that the role of the expert is to my mind, depending on the type of case, is as much about the eventual opinion that the expert gets to as it is about identifying what facts are relevant and ought to be taken into account.
Right.
Now, that's a point you've already made at paragraph 1.1.4 of your handbook, much earlier in the handbook, where you talk about the nature of expert evidence, and you say that the expert evidence is put before the court, or is used to put before the court facts that require specialist skill to ascertain. And I think that's what we're talking about here.
Very much so.
That's where an expert accountant, you or I are going to read this massive stuff trying to prepare for a trial. We're not going to know what on earth is relevant, what isn't relevant. Neither does your liquidator, because they also don't. And then you get an expert in and you get somebody to then help you to record, normally in the expert report, and identify the facts that are relevant, and often it takes specialist skill or expertise to even identify and tease out those facts.
Yeah, now Craig, you see that resonates very strongly with medical malpractice or personal injury type work, particularly medical malpractice, where the big difference between road accident fund work and medical malpractice work, as far as liability is concerned, is that the question of the sort of factual matrix around the question of negligence. When you're doing the road accident fund work, it's generally a lot simpler. It's a motor vehicle accident. Medical malpractice work, you're dealing with the question of whether the practitioner complied with the requisite standard of the reasonable practitioner within the circumstances of the case. That is, as you can imagine, a far more subtle and complex inquiry, and often really stretches seasoned experts within that field as to what the correct position is. And what I do find in medical malpractice work is often what happens is that the question of whether the practitioner was negligent or not may turn on literally a squiggle on a page. because there's all this notation that doctors use. It's absolutely impossible for the advocate or the judge to understand what has happened factually. And so the point you're making, which I can understand, and I'm getting an insight into the nature of your work and the complexity of understanding what's happened in the life of a company. But it resonates very strongly in the medical malpractice field, because often it's that the proper marshalling and understanding of the facts is what will decide that case one way or the other. So it's a very, very important point, this.
Absolutely. So it's quite a heavy responsibility on the experts, because
Yeah,
it's both, to some extent establishing what the pertinent facts are, uh, what facts are of legal significance, and then also expressing an opinion on those facts as well.
indeed.
But and so we use, unabashedly, in those circumstances, we use an expert accountant as a bit of a cheat code, so that we've got somebody in the witness box, and we
Uh-huh.
can use the accountant to lead a narrative effectively of
Mm.
what the affairs were of the company.
Okay, very interesting. Yeah.
Yeah, and then if you're happy with that, Ian, um,
No, very good,
the
Craig.
next point was
Mm.
the next point was joint minutes.
Well, just give me the paragraph number there, please.
That's 4.2.3.
Just bear with me.
Joint minutes. Joint minutes. Like every good advocate, I've got a flag in my documents
Very good.
that's supposed to tell me
Yeah,
where
there you
to
go.
go. There we go.
Right, conducting joint meetings. Got it.
Now, yeah, and this is, yeah, conducting the joint meetings. Now, here we must just explain that the how the trial procedure works is that the usually the experts from on either side will deliver their expert reports. I mean, every now and again you have a situation where one side delivers expert reports and the other side doesn't use an expert at all. That's fairly uncommon. My sense is that generally, if there's a generally if you'll have both sides will submit expert reports, and then the rules of court, the High Court rules of court, actually then provide that the parties then the experts must, I think it's within 20 days of the last report being filed, the expert witnesses on either side must meet. They must have a conference, and they must file a joint minute for the assistance of the court. And in that joint minute, they've got to deal with. We'll look shortly at what's got to be in there. But it's basically a recordal of where the parties are able to find common ground and where they're not. Now, and you make the critical point at 4.2.3, just ahead of your tips for experts there, that it should not be the joint meetings should not be seen as nothing more than a necessary formality in order to secure a trial date, and they should not be conducted telephonically or by way of correspondence without any engagement on the nature of the disputes between the parties. Now, that's the golden rule. I absolutely agree with that, because it's absolutely critical for folks to understand that we use that part of the art of utilizing expert evidence is not just telling your own story in court and propping up your own case in court, but it's all about narrowing the issues that are in dispute, both on the facts and on the opinion side of things. So what you'll find is, and it's an absolutely critical part of the pre-trial process, because the idea is, if you've got sensible experts, and they've met and they've properly applied their minds, then You may start on the pleadings, you may have, just by way of example, 10 issues in dispute, but by the time that the experts have got together and they've sensibly each engaged, they do so in circumstances where they're not just a mouthpiece for one of the parties. They understand their obligation is ultimately to the court as an independent expert to be of assistance to the court. Then you may find yourself with a joint minute prepared by the experts where they've now managed to reduce the issues in dispute to, say, 5.
Yeah.
So the whole point is, then you only really have to go to court and lead evidence on the remaining 5 issues that are in dispute. So it massively curtails the necessity to lead evidence and the running of the trial and the complexity of the trial when you get your experts who've successfully managed to meet in a joint meeting and prepare a minute where they've managed to narrow the issues.
Very much so, Craig. And if I can I just want to make one point. It's a little bit practical in nature, but it has an important conceptual implication. Under 4.2.3, the comments that I make, in fact, it's not immediately obvious, but on the top of the next page, there's reference to the decision of AM and another versus MEC for Health Western Cape, a Supreme Court of Appeal decision made in 2021, where that principle was spelt out in that judgment. And in fact, the judgment is interesting in this regard because what you're saying is completely in line with what the courts expect. And I would just add that the courts actually expect the experts to actively engage in that narrowing of issues exercise, and that was one of the points made in AM and another. So the importance of that duty on the shoulders of the experts must be emphasized, and it is certainly it's expected from the courts that they engage in that narrowing process.
Excellent. Yes, and then I think you've got your tips for experts, joint meeting of experts.
Yeah.
And I think you were there earlier. I think all the points that you've raised there are good. Number one being making sure that the documents you've been provided are complete and up to date. Well, quite often even counsel don't have complete and up to date documents where you're dealing with overburdened attorneys that haven't made sure that everyone's got the right documents. It sounds like an obvious point, but you can imagine the disaster if you're as an expert, you're preparing and attending a joint meeting of experts where you don't have the latest pleadings, you don't have the latest documents. So it's a total mess. So the same point is at points 2, where you should ask for an updated index. 3, prepare properly for the meeting. Make sure you've read the relevant documents. 4, consider the agenda for the meeting. I might just point out the agenda is quite an important thing because as an expert, you want to be, especially if you're the expert for the plaintiff, you want to be, to an extent, hopefully, if you're a strong expert witness, and you have a backbone, I think, it was your tips for cross-examination is that the experts, you've got to take it. You have to. The other way you put it today was you've got to grasp the nettle.
Yeah,
and that's expected of an expert. And so you need to go into these meetings properly prepared. You need to be strong, reasonable but strong on your view. And to keep control of the meeting. And I'm going to give you an example now of a matter where I've got where there's a huge expert, a joint expert meeting that's going to be happening in 5 days. And I'll explain now how important even maintaining control over formulating the agenda is important because, when you put the document together yourself, you have narrative control over what's going to be considered. But so formulating the agenda properly is important to make sure that all of the issues that you as expert want to have covered are properly dealt with. And 5 is critical. And I'm going to stop here now. I'm actually going to tell you my story, my practical story. So I've got a construction case at the moment. So 5, you've said, agree with the other expert that enough time will be allocated for a proper discussion, with plenty of time for the meeting. Do not regard the meeting as a mere formality. It's absolutely critical. So I've got a construction matter. I'm running the matter for the plaintiff. I appear with a well-known silk, but of course you'll know, being a senior junior yourself, that often you've got an overburdened senior advocate, and really you're running the case, and you're going to, at the last minute, you're going to brief him up and get him up to speed. But basically, you're running around trying to keep the case on track.
Yeah.
And so I've got this construction case involving a whole bunch of government contracts in the Western Cape, involving a very well-known developer, builder. And we've got this a joint meeting coming up on the 9th of September. And we've got 4 experts, and they've got 5 experts.
Yeah.
Now, and they're all the experts. It's like a jigsaw puzzle. We've kind of slotted them in together. Some of them deal with some aspects, some deal with other aspects. What we're desperately trying to avoid, and I'm not sure that we're going to get there, is a nuts and bolts type of construction case where you've got a line by line disputes about whether or not, whatever line item in a bill of quantities, whether that was actually, the work was actually performed, and what the fair and reasonable price was for that work. So I've been hammering on at my poor experts about please trying to narrow that gap, and trying to make sure that the case is conducted on the big ticket items. Like, for example, the other side say, well, there were delays and there were defects and there were penalties. Those are all things that you can deal with almost on a kind of contractual basis, and you can deal with their big ticket items.
Performance, yeah.
So long story short, I've got 4, they've got 5. We've spent a lot of time, our reports are all in. We've spent a lot of time sitting again with the experts and trying to help them to prepare for this upcoming meeting that everyone's quite nervous about. To be frank, I wish I had your handbook, and I wish I had the rights to be able to make copies of it and to give it to my guys ahead of the meeting, because I think that would settle them a little bit, because there's really not much out there in terms of giving them some advice as to how to approach the meeting.
Yeah.
And the point is this, we're trying to get the meeting convened, and then the messages start coming in. No, well, 2 of the guys on the other side are busy in that week because they're quantity surveyors and they have to be on a site in KZN. Meanwhile, your meeting's in Cape Town, so they can't attend the meeting. They want to dial in virtually. And I said no. And then one of our guys wasn't available because he's now working for somebody else, unfortunately. So one of our experts, and he wanted to dial in. I said to my attorneys, no. So it was no. And so we've waited like 6 weeks, I think, to try and get everyone into a room together. But finally, we got all of these 4 and 5 experts. We got them all flying into Cape Town. We got them all to commit eventually to setting 2 days aside for the joint meeting. And they've been given, some of them are being put up in a nice hotel somewhere, and they've got access to a boardroom, and they've got access to breakaway rooms. And I'm glad to say that I think we've set the scene properly now, that they're all going to be in the same room, and they're all going to dedicate enough time to trying to sort the issues. And that, I think, is the practical example of your paragraph 5 that we're looking at, which is it's not a mere formality.
Correct.
For us, the whole case turns on this. The whole way we run the matter is going to turn on what the outcome is of this meeting. It's absolutely critical.
But Craig, this is a very good illustration of the principles. And if you have a look at that AM judgment, you'll see, I think it's actually a judgment by Wallace, where he underscores the importance of doing the exact exercise that, and I talk about backbone, also takes backbone of counsel, where you say, no, you can't dial in, you will be here. Because if you, look, some cases can be dealt with via a Zoom meeting. You know, the sort of more standard, sort of a road accident fund type case where there's one expert on each side. Really, there's not terribly much in dispute. But what you're talking about now is a proper multifaceted dispute with a number of experts, and there's only one way to resolve that. Exactly as you say, they've got to sit down at the table together, they've got to be properly prepared, and they've got to apply their minds properly. And then every effort must be made to narrow the issues. Of course, you may not even get very far, but it's incumbent on the experts to have a proper attempt at it. And my experience, and I don't know what will happen in your case, but my experience is that once you get those experts together, properly applying their minds, you actually can generally make considerable progress in weeding out what is not really an issue. And at the end of that process, come up with, right, this is what's really an issue. Let's spend time and money on resolving the true disputes in the case. Yeah.
And that really, I mean, that takes us to the next phase of what we need to discuss, which is what must be in the joint minute.
Yeah.
And just on this example basis, I mean, the joint minute must really be ultimately a shopping list of the issues that are still in dispute.
Correct.
And need to be determined.
Correct.
And just to that end, I'll just say, I mean, the rest of the points you've got that we're looking at now are extremely, they're all apposite. You've set out what should happen where there are disagreements at 8 and 9. And then at 10, you make the point, and it will lead into the joint minute. Yeah. Never sign anything you don't agree with, please. That is absolutely critical.
Yeah.
And you find, because the problem is so that the principles, as I understand it, are that once you as the expert have agreed, let's say you're there for me, for the plaintiff, once you've agreed on issues and effectively signed off on it, then the plaintiff is going to be my client, therefore, to a degree, your client as well, is going to be bound by the concessions that you've made in signing that minute.
100%.
Now, there's a whole body of case law. I mean, you've got it amply set out in your in the handbook about, you know, when a court can go behind that.
Yeah.
So, yeah, a court's. I mean, if experts agree on an opinion aspect and the court doesn't agree, the court's not bound by that, because ultimately the experts are there to assist the court. But on a factual level, I think it's a bit more difficult. I think generally, once the experts are in agreement about what the pertinent and established facts are, then a court will be fairly slow to go against that.
Well, Craig, that's B versus Road Accident Fund, and in fact the principle is that once you it's agreed in the joint minute, that becomes common cause between the parties, and as a general rule, the part that no longer needs to be proven. There are exceptions, but what needs to happen? So you can repudiate that agreement, but you need to give what the court refers to as fair notice to the other side. In other words, there must be timeous notice that you no longer regard yourself as being bound. So it's not just there for the asking. And the other thing about fair notice, and you'll appreciate this, is in fact, the judgment says you can't, for instance, or be very difficult on the day of trial to give that notice, because the other side will be prejudiced. That could lead to all sorts of difficulties relating to adjournments and paying of wasted costs and all sorts of terrible consequences. You may not even get your adjournment. So you'd have to then formally request the adjournment, explain why this wasn't done earlier, and it becomes an absolute mess. So I just really want to emphasize what you've said there, Craig. It is so important that when an expert signs a joint minute, that they're very clear about what the issues are and what their perspective on those, what their position is on those issues, and that they must be in complete agreement with every word of that minute. It's very important.
Absolutely agree. It couldn't. I mean, as you say, the consequences of them trying to go against that are going to cost your client a serious amount of money trying to undo any concessions that you've made in that regard.
Indeed.
And then the form and content. So just as to the joint minute generally, and I think you've made this point, it's form and content of the joint minute. And certainly when I was preparing, I saw a point that you made there that that the parties must jointly record what they agree on, but it's also critical to realize they must also record what they don't agree on.
Yeah.
And the respective reasoning therefore to serve effectively as a guide to the judge as to what's going to need to be decided.
Yeah, it's just, I think it's that paragraph just above HEL on behalf of MML versus MEC for Health, where I say, if the parties choose to place an agreed minute before the court reflecting both shared opinions and areas of disagreement, and do not call the parties to the minute to deal with the areas of disagreement, the minute will do no more than reflect that there's disagreement on those points. In other words, they should set out the basis of the disagreement in the minute as well. It shouldn't just say that there's disagreement. Yeah.
Yes. And just from my side, just from the practical perspective, really just to sum up how we use experts in principle is for the expert when they're going through this exercise, when they're going to the meeting, when they are making recordals in the joint minute and eventually signing the joint minute, is to always bear in mind the hallowed principles of first being absolutely sure that they're happy with what they're signing, and secondly, that the overall object of the exercise is to narrow the issues between the parties, both at a factual level and at an opinion level. So it can be that as a result of a 2-day a joint expert meeting where the parties are locked into a room, they may not have the same opinion on certain issues, but they may at least be able to agree what the pertinent facts are, what the common cause facts are upon which the opinion is premised. And then we can then curtail the proceedings, because one doesn't have to worry about a dispute about what the facts are, and one can go straight to the opinion, and one can then start testing the opinion rather than having to spend all that time establishing what the facts are beforehand. And in that way, we curtail the running of the trial hugely.
Yeah, no, excellent. Oh, well, Craig, that's been absolutely fascinating and a wonderful discussion. I must say, I expected that this may happen, and it certainly has happened. Is just from seeing, I think it's very useful to speak to somebody like you, where you're not coming purely from a personal injury perspective. You've got a slightly different angle on the same principles, and it's interesting to unpack those principles. And I think really what you, to my mind, and other viewers may have taken other things as well, but to me the main thing that came out is that marshalling of the facts and the role of the expert witness in understanding the facts. And then the point that you used, which is so important, is creating a narrative. In other words, telling a story, because that's how our brains understand things, especially complex facts.
Absolutely.
Start at the beginning and tell the judge a story so that they can understand. That's how we will get to understand exactly what you say, the narrative. And a strong narrative is very helpful in litigation.
Absolutely.
Craig, thank you so much. Sorry, you were going to say.
No, just I mean, it's always helpful to understand that the person sitting up on the bench, or your arbitrator, is really just is a human. Yeah. And sometimes we need to pique their interest, and as you say, telling a story in an interesting, simplified fashion is really the way to go about kind of piquing their interest in the more technical aspects of the case through using a narrative.
Absolutely right, and that's how they'll put it together. Yeah, that point is also, it shouldn't be lost. It's very important in how you present it, and even for the experts, how the experts present sometimes quite technical information. You do need to humanize it and put it into a story, and then the judge or the arbitrator is so much easier for them to follow. Craig, thank you so much. Absolutely. It's been fantastic, and I've learned a lot. I found it very, very interesting, And yeah, we will, I'm sure, chat soon. And good luck with your expert witness jamboree in 5 days' time. I hope they narrow their
I'm
issues.
praying. I'm hoping. Thanks, Ian.
All right.
Thanks for
Okay,
having
good,
me.
Craig.
It's been
Excellent.
interesting.
Cheers. We'll chat soon.
Thank you.
Cheers, then. Bye bye. All the best. Bye
Cheers.
bye.
Bye.